Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Great day yesterday. I mean, this morning. Woke up to fantastic news. I think we'll start it off. Doesn't everybody love good news? I think we'll start off the show with some good news. Straight out of California, the awful, horrible DA, George Gascon, voted out of office in a ridiculous margin, 23 points. LA Democrats says no to the DA who got rid of the entire department that notified victims' families when their loved one's killer came up for parole. No to the soft on crime policies. No to the idea of having 2 defense attorneys talking to themselves in court, and no DA representing the victim or the people. No. So pop the champagne. George Gascon is now a thing of the past. And not only did they get out George Gascon, but they passed Proposition 36, which got rid of Proposition 47, which was their soft on crimes proposition, which made theft under 1,000. Reminds me of the Trailer Park Boys. Shout out to anyone who watches the Trailer Park Boys. Anything under theft under 1,000, got rid of that policy. And maybe we will see our justice system starting to be restored all over America. I mean, this is a fantastic start. If you don't know, George Gascon is the one who orchestrated, or was the architect, is a better way, with the Open Society Foundation's money, of putting in all these former defense attorneys and having them run as district attorney. So putting in really another defense attorney as district attorney, and the district attorney's interest in states like Baltimore, New York, we still unfortunately have one, Alvin Bragg. Chicago saw just 2 defense attorneys talking to themselves in court. So that was pretty much the most overwhelming news for me from last night's election. I just couldn't believe it. I know that he was down in the polls terribly. He tried to come back with setting free the Menendezes, and pleasing the Menendezes' large TikTok fan base, but that was a fail for George Gascon. So seldom do we get great news like this. So I'm just, excuse me while I savor it a bit. Hey, B Rabbit, thanks for becoming a new member. Dean Walker, nice to see you. Hope your grandbaby is well. Thanks for the super sticker. So, big news in Karen Reed's case. Boy, is the Free Karen Reed. Hold on one second. The Free Karen Reed side is imploding. And the first defector is Sean McDonough from the Going Through the Motions. He's hasn't totally defected. He's going to appear on Masshole Troll Mafia's channel at 7. So I'm going to try to be mindful of that and have us get off in time so we can all go over to Kate's channel and watch that interview. He's going to be interviewed. But boy, did he spill a biggie on his Twitter. Let me pull up. Hold on. Let me just pull up his text first. I bookmarked it. Here we go. It's so weird the way Twitter does this now with the bookmarks. Okay. So everybody can see. Oh, nope, wrong one. Wrong one. Well, here we go. So it starts out, okay, people, I'll fess up. The little emperor is right. So I think he means Aidan Kearney. Karen never spoke to me, never texted me, never tasked me to do special investigations for her, never meddled with me in the OG group, and never asked me to use the Signal app. I made it all up. I don't know how the volumes of text and intel from her ended up in my phone. Seriously, just go with Emperor. He'll never lie to you. Just me. I mean, Aidan Kearney is really gaining a lot of power in that group. And, you know, what Sean's honing in on is just how much of a cult leader he is. I mean, he's even said, like, just believe me. Just believe me. Don't think for yourself. Just believe me. And he's got a just me. I mean, even the new podcast, if you caught last episode, 40% of it is going to Aidan Kearney. 40% of the profits of 34 Fairview and William Phelps' new podcast is going right to Aidan Kearney. So don't pay any more attention to me, please. But hey, I still believe, yeah, he keeps doing this. What is that? 100,000% she is innocent? Yeah, so here's Karen Reed saying, hey, the J. Roberts stuff is insane. So this was a supporter who became a non-supporter. He was at every hearing from the jump, way too invested. I remember he asked Natalie to ask me to save him a seat, and I said I couldn't. Then she asked me to ask my parents, like, this isn't a pep rally. We are overwhelmed on hearing days and can't save random strangers a seat. Really? How did anyone get the idea that it was a pep rally with the full cheerleaders in tow? How did anyone get these hearings confused or the trial confused with a pep rally? Isn't that amazing, guys? The courtroom is hostile as it is. I know Jay and Natalie were annoyed when I said no. What a weirdo Jay is. So maybe this is before they switched. I don't know. Aidan is a risk. I have been so careful. So she's talking, Karen Reed's talking about Aidan Kearney. Aidan is a risk. I have been so careful to lay low, and he blows it all up. Last month, they took my phone that I had for 2 years. It had tons on it, and that's all from the Lindsay mess. I can't expose myself to that anymore. So that is the SA accusation. If you don't know, against him. And that's what Karen Reed does. She's totally the woman behind the curtain, but will lay back, and cover her tracks. Has a criminal mind. So they have her phone and it has tons on it. And this is apparently the grand jury would not indict her on witness harassment, which I find so weird. Just from I've read you the court filing against Aidan, and it's so clear that first she used Natalie as a go-between, and then between herself and Aidan Turtleboy Kearney, and then she's just started, when Natalie dropped out, started texting him directly via an encrypted app. So I don't know what kind of case they made to the grand jury, but boy, are the Turtle Riders celebrating that accomplishment. Like, well, she's clearly innocent because we didn't meet our standard of evidence. They always say a grand jury will indict a ham sandwich. Clearly not. They'll indict a ham sandwich, but they won't indict someone clearly behind, in my opinion, behind a witness harassment campaign. We also got your comments from last episode. We were talking about the new 34 Fairview. I think it's a dumpster fire of a podcast. Unimpressed by it, but so M. William Phelps is giving 40% of his profits to it. And the non-supporters are like, the guy's a genius. We love him. He said she's not guilty. That's just the criteria, apparently, for producing good content. Just say Karen Reed's guilty. It doesn't matter that 40% of the profits are going to Aidan Turtleboy Kearney. Don't question it. It's just enough to say she's guilty, and don't question his motives. And I made all sorts of connections with his manager and the innocence fraudster Amy Berg, and his connection with having criminal clients. I mean, that's not my opinion. The guy is literally in prison. And that's the manager that represents Aidan and represents M. William Phelps. But got some comments. Wesley Loves Oktoberfest says, okay, Roberta, you're opening a can of worms. Don't I always? The Free Karen Reed group is a cult. She's guilty as sin. Keep reporting the truth, even if the majority doesn't want to hear it. Everyone wants to kill the messenger. I can't wait until your next true crime report. There's a lot of crazy out there. Sure is, and we're going through some of it today. Otis Buttress left many messages. He tells the truth, meaning Aidan Kearney, and all of you are jealous of him and his success. Well, I'm so glad that you said this, because I was getting a little homesick, if there's such a word for it, for all the people who used to say I was just jealous of Karen Reed, jealous of her beauty. So I guess I'm jealous of Aidan too, and his success. He does tell some of the truth, but he tells a lot of nonsense. I don't think you can fully do what he does without telling a tiny little bit of the truth, but it's mixed in with a whole lot of untruth telling, as most innocence fraud campaigns are. Sophia Constantine said 1248 says Karen Reed did a Sarah Boone on John O'Keefe. You are absolutely 100% correct. There's a new quote from Karen Reed out in the Vanity Fair article. I'll get to it in a second. it wasn't out of drunk anger. It was out of drunk anger, rage, and revenge. I don't think she was that drunk. I really don't think alcohol touches the sides. I've never argued that she was that drunk. I think it was the end of what we see as relationship violence. That was the end result. That's my feeling. You know, I mean, there was a free Karen reader on here saying, well, isn't it strange, you know, you guys, he just assumed, I guess, that I was arguing that she's so drunk. But he's like, didn't you notice nobody said she was drunk? And I was like, yeah, that's my point. I think she, I don't know, what, has a hollow leg? I don't know. What do you call it? I don't think alcohol touches the sides with her. I really don't. Police officers are trained to look for drunkenness. No one said she was that drunk. I mean, maybe alcohol loosens her inhibitions a tad, but I doubt it. I mean, the real question is, how premeditated was this? Had she been fantasizing about this for a long time? So here's in the new Vanity Fair, Karen Reed reflects on her relationship with John and whether she still mourns his loss. We argued, Reed admits, but was I abusive? Was I neglectful? Did I mistreat him emotionally or in any way? Or did we have ups and downs? And I helped him tend to the kids, and we went on vacations and sporting events and school and breakfasts and haircuts. So it's like, if I was abusive, I would have never gone on vacations and helped with the kids and sporting events and school breakfasts and done haircuts. Hold on one second. Let me let my cat out. Who else has that, right? You just like close the door. My boyfriend closed the door. So he's making a phone call, and the cat was just like, rah! As soon as you close the door, it's like, rah! I'm trapped. Okay. So, I mean, but who would do this? My question is, who would do this? Like, just think about someone in your life who has died, not even you've been accused of murder. But would you say, would you even ask yourself, was I abusive? Have you ever, does that question ever come up? Was I abusive? Or did we just have ups and downs? Obviously you were. She's just putting out the idea that, was I neglectful? Did I mistreat him emotionally or in any way? Would you be worrying about that if it wasn't an issue? I mean, I think she's really heading off the people like me who said, look, you know, this is the end result of relationship violence. This is the final chapter. I win. She also addresses whether she was the happiest murder defendant. That's something I've accused her of being, the happiest murder defendant. And she repeats it verbatim. She's like, well, I guess I am the happiest murder defendant because I'm innocent. That's why I'm so happy, because I'm innocent, guys. It's a crazy piece. I got to go through that Vanity Fair article. But in other news, Karen Reed got to speak to the Supreme Court, or their highest court, I assume it's the Supreme Court of Massachusetts, over their issue with the jurors, meaning the judge declared a mistrial and the defense says, oh no, they wanted to acquit on the two charges, strangely the two strongest charges, leaving the scene of an accident, causing injury or death, and second-degree murder. Here is a little news story on it, and then we'll get into the actual hearing. Take a listen.
All right, let's get to the latest now in the Karen Read case. We are now awaiting a ruling from Massachusetts' highest court. Her attorneys are hoping they have convinced the Supreme Judicial Court that some of the charges against her, 2 of the 3 charges, should be dropped. Our John Maroney is live for us in Boston outside the state Supreme Judicial Court, where both sides made their arguments heard this morning in front of the justices. John, good morning.
Good morning, Melanie. A lot of questions from judges on the SJC this morning regarding Karen Read's murder trial. Read and her attorneys, they arrived here in downtown at the courthouse shortly before 9 o'clock this morning. They're trying to get 2 of 3 charges dismissed, including second-degree murder and leave.
Okay, what is up with Alan Jackson? My friend said, you got to see Alan Jackson's face. He looks like he has shoe polish on his face. And I didn't believe her until I actually saw it. The beard, maybe he thinks that the Free Karen Read people will think he's been replaced. You know the theory that, like the Beatles theory? Maybe they think, like, if I grow a beard, maybe the Free Karen Readers will think I've been replaced and I'm just an entirely new Alan Jackson, the one who wasn't caught with my hands on Karen Read's breasts. So bad. Such a bad look for him.
Leaving the scene of an accident. The defense says retrying her on those charges would result in double jeopardy. She's, of course, accused of hitting and killing her boyfriend, John O'Keefe, with her SUV. A mistrial was declared in July, but a group of jurors contacted defense lawyers saying that they had found her not guilty of those charges in question. Judge Beverly Cannoni rejected a request from Read's attorneys to dismiss them outright or even poll the jurors, prompting this appeal to the state Supreme Court. Now, the attorney for the prosecution told the SJC the judge acted properly. The defense wants the case sent back to her to find out what the jury was thinking.
I thought they were extraordinarily intelligent. They obviously know the facts extremely well. They're interested. It was an active bench, which all bodes well for us.
We remain hopeful and confident because we have the facts. We've been benefited by the federal government. U.S. Attorney has provided us with a...
Right. Why has the federal government just chosen to get involved in this case? That question has not been answered. And why did those witnesses testify? Not incredibly helpful, but like Dominic Dunn says, jurors are fooled by those expert witnesses all the time.
Of evidence that is clearly supportive of Karen Read's innocence.
Now, no word on when the SJC will make its ruling. Karen Read's retrial is set for the end of January, but both sides have now asked for an extension. Well, live in Boston, John Maroney, NBC 10 Boston.
You know, I mean, that's not the first time. I'm just going back to Karen Read talking about, was I abusive? It's not the first time she's claimed to, like, thrown out the truth and claimed it was a question. Did I hit him? It was preceded by a did. I hit him. It was preceded by a did and proceeded by a question mark. Was I abusive? It was preceded by was and proceeded by a question mark. Could I have really been absolutely, could me running John O'Keefe over 24 miles an hour in reverse, never once hitting the brake, with my infotainment system beeping, could that really be my final victory in the end product of all my abuse? The final middle finger? Could it be? I'm just asking a question, guys. Could it have been? Just wondering out loud. So here's the hearing today.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston, within and for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
Okay, good morning, Madam Clerk.
You'll see they ask a lot of skeptical questions, and the defense brings in the Boston Bombers case into this. Kind of wild. But they were hammered with one skeptical question after the other, if that's what Alan Jackson wants to call an engaged and active and knowledgeable bench. Okay.
JC 13663, Commonwealth versus Karen Reed. Attorney Weinberg.
Good morning, Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant Karen Reed. Today's appeal goes to the core issues regarding double jeopardy protection that safeguard defendants, in this case Ms. Reed, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first...
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to...
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof that a 5th juror contacted the defense. A juror who could have been one of the 5 and could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence...
Come on, guys. When I say 7 or 8, I mean 5. I mean 4. I mean 3. I mean 5. I mean sort of. I mean 4 and maybe 1 more showed proof. What I hear is, I mean, from my sources say that there were 2 turtle riders on the jury. And that's been supported, at least one of them's been supported by the fact that Kevin from Yellow Cottage Tales tried to interview one of them, and she went right back to Turtleboy with it. So, I mean, I guess you could argue that she only became sympathetic after the trial, but to my mind, it speaks much more to the idea that she was watching his content beforehand and got herself on the jury, as he told his followers to do. Get on the jury. Just don't get caught. Anybody remember that?
Strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding...
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous decision.
Well, you cite Taylor, which is the case in Quincy where the judge, basically, there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case. and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error. Yes. That case is an opposite to what the situation. So how do we say it was?
Excuse me, Mr. Weisberg, you're calling a verdict this a verdict when we know a verdict has to be signed, sworn, handed in on paper. You have none of those things. How are you calling this a verdict? It's like, well, and he's citing some case that's like something went wrong. They didn't follow court procedure. I mean, okay. Some juvenile case, of course. I mean, they work so hard to undo those juvenile cases. Check out any of my episodes with Jane from the National Organization of Victims of Juvenile Murderers. Kitties, 1993. Nice to see you, Kitties. Says, how do we know Turtleboy didn't get creative and the attorneys don't know what they don't know? They have to poll anyway. Nice try. Didn't get creative and they don't know what they don't know. You mean, how do we know that they're actual proof? Yeah, I don't know. I mean, obviously they could say that anyone got in touch with them. They claim that they have proof. I've heard that they have, I don't know, that there's, that the real issue was with 2 jurors. I don't know. They claim 4, 8, 4, 5, 6. Make it up as you go along, kitties. I don't know. Thanks. I don't know. I mean, certainly I get the feeling, this is just me, of an entirely lawless defense team. So when you put out leaks to your blogger that's basically like another arm of the defense, and then quote the bloggers that you've leaked to's leaks that just come from you and quote it in your filings as it's been reported. I call that highly irregular and not following the rules of your profession. So if they can't follow the rules in their profession, their own filings, I don't know what's stopping them from being lawless in other ways. So anything's on the table. I just can't know what went on behind the scenes. And that's why I always encourage everyone to watch the documentary Murder in the Park, because you get to see what went behind an undoing of a conviction. Anthony Porter's conviction in Chicago, and it's so sleazy. People being offered book money, movie money, just guilting eyewitnesses to death. Haranguing them until they go back on their statements, offering to help with a lawyer for someone's cousin who's in jail, prison, excuse me. We just can't know these things on the front face of
an acquittal without a verdict in open court and no verdict slip.
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declarations.
But that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict.
Did you guys all hear that? He's like, we've more than met the burden, and instead of saying burden of proof, he says burden of production. We're producing a lot of nonsense and BS over here and presenting it to the court. We're in the business of producing all the time. We're producing nonsense all the time, and the gullible public is buying it. And they're buying nonsense on both sides. You know, this has more disinformation going on both sides. And I think that's been a real, how do I say it? A real issue with the non-supportive side is this sort of just willingness to kind of accept anything and everybody at face value who just says she's guilty as wonderful and brave and good journalism, even when 40% of it's going to Turtleboy, into his pocket. Just consume it. It's good. Consume it.
Inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was...
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence. But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Jeri.
You seek to impeach the written communication of the foreperson, correct?
I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges, but count two by itself, read vertically, had multiple charges. Horizontally, there were three separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least three viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words in deadlock.
There's no inkling of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best, it's exhausted, it's tried every option, and everyone's resigned to trying the case again. I understand something happens later.
They're like, well, you're using these notes from the jury foreperson who's exhausted. You really want to read into them like tea leaves? Like, don't think so. Good news. Kate's not going on till 8 o'clock, so we have a little bit more time to watch this all together. If you guys are up for it, I am. I mean, anything that Karen Reed's team does is going to say it's a win. There are no losses on Karen Reed's side, right? Mistrial, great, it's a win. Even though they know that statistically, it's not very good for them next time up, that the conviction is more certain second time round. That was a win. This was a win. These judges don't seem to be buying it at all. I remember sitting in a lot of these hearings. Usually there were like pre-trial hearings, and they were trying to get in evidence or keep out evidence. And when you get peppered with nothing but skeptical questions, that it's not going well for you. And I don't think the judges are looking into what direction legally they can rule, and there's nowhere for them to go. You can see by their questions, like, well, doesn't this say this? We can't do it because of this. And they're looking to be persuaded, and they be interested to see if they can be persuaded. But
at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Campbell versus Enid Brown, where the jury was sent? The jury goofed, essentially. There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge?
I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do, the lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago, was Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question, and has no capacity to coerce the jury into redeliberating. It would illuminate the implied ambiguity which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note.
Yes.
That would indicate any less of an impasse between the first, second, and third notes?
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury.
Okay, so that's an interesting little part there. I don't know if you guys caught that. So what she says is like, I'm not asking for an argument. Can you tell me between when they were given this Rodriguez reading, Tui Rodriguez reading, which means like do everything you can to come to a verdict, everything you can. Between the second and, when they came back, can you tell me anything that makes you think that they had come to an agreement on anything? And he's like, well, my proof is that they went in and deliberated. That's hardly convincing. She's like, I'm not asking for an argument. Show me in the record any indication that this jury agreed on any of the charges at all. And he's like, well, my proof is that they went back into the room and deliberated, Your Honor. It's almost comical, this thing. This reminds me of, I'm getting deja vu from Mark Agnifilo, who is, now he's Puff Daddy's lawyer, but he was Keith Raniere's lawyer. He would make arguments like this. And you'd be like, what? That's your proof? Yeah, my proof is that they were deliberating. Okay.
To reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would...
Right, so she's like, so there's no indication that they were at any less of an impasse when they write the first note than the third time they came back. Just the fact that they walked in a room and came out. Okay.
Contend that all three notes are ambiguous. The defense...
That was not the argument you made below.
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was that there was ambiguity.
Not at the motion to dismiss, at the time.
They had no opportunity at the time to...
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a request for TUI.
Was there any ambiguity argument made in response to the second note?
There was a request for TUI. But the only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Discassiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which...
Right. So there was no opportunity to ask the jury, do you have a partial verdict, is his argument here. But don't you think if they had come to a partial verdict, they would have said so on anything? I just don't buy this. To me, this seems like trying to get the heaviest charges against Karen Reed, which is the second-degree murder charge and the leaving the scene of an accident causing murder or death charge dropped. And they see an opportunity here. Because, I mean, if we can go back in time, and I think that's what that one judge did rather nicely and looked at the record, but I can go back in my memory and pull up the video of the time when a mistrial was declared. The defense was all celebrating. Nobody was asking at the time, well, did they get a partial verdict? Well, they would say, well, because we didn't know. No, none of the jury had come to us. Isn't it funny that the jury ran right to the defense? Certain members of the jury, if that's what really happened, ran right to the defense. And of course, the prosecution said, you know, we did get a call from one juror, but we can't talk to them. We can't discuss any part of their deliberation.
Says before a mistrial, a court may request of a jury whether or not they've reached.
So my question is, why was the defense allowed to have that conversation and not the prosecution? And is this yet another time when we see the perpetual line stepping, my view, defense team crossing over into sleazy territory? Was this sleazy territory, or is the defense allowed and not the state? Seems unusual, right? That would be so, but
any decision on any of the other counts. The reporter's notes.
At the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where, again, they report that they're in an impasse, quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez, and she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agreed that beyond a reasonable doubt, the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for one.
So your rule would be that anytime there's more than 1 charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a mistrial.
I thought there was a may, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
And in the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples, but 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement, on a particular verdict, correct?
Yes, those notes were subject to one of two interpretations, and given the obligation of a trial court to consider.
Does anyone know what this little timer here? It looked like it had 30 minutes in the beginning, but am I losing my mind and thinking is it by answer, or does he have, like, say 3 minutes when asked a question to answer, in a certain amount of time to make his argument, and then a certain amount of time for each answer? Or is it just 30 minutes for the whole argument and answer period on each side? Because this is an hour-long hearing.
Consider all alternatives, including the alternative post-Tui of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration
As a matter
of
of
these
fact, were
alternatives.
there 3 separate verdict forms?
There was actually more than 3 verdict forms, because the verdicts on count 2.
There's a sympathetic question. So I caught someone in the chat saying, "Oh, they always ask skeptical questions." Now, I've never been to a Supreme Court hearing like this, and I know it's a little different. I've seen a bunch of them. Thinking of one in Oscar Pistorius's case in South Africa, so maybe that doesn't count. I've seen a few of these, but just the hearings I've been to, like, you can just tell, like, there's a sympathetic question. There were 3 different jury forms. They really had to work to find these jury forms, and then they changed it to clarify it in the way that the defense wanted it to. So it's really hard for the defense to argue after the fact, but maybe this judge is going to see it as sympathetic, that the jury forms were so confusing and that they didn't know they had the option to agree on some charges and not the other. My experience as a juror just recently on a criminal trial was that we were all so scared of doing anything wrong. We asked 100,000 times to make sure we were doing everything right. But I guess you could argue, if you're a defense attorney trying to get your guilty client off of the most serious charges, that they were also over emotional and exhausted, that they might not have taken that extra step of asking those questions. I just doubt it. And I think the judges doubt this argument too.
Had multiple, they had 3
So
different options.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations. Can you tell us how?
Yes.
Why? How would she do this? She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on that.
My thought process, one, is that this court has the option of essentially informing the court what questions could be asked, and 2, if we're going to delegate,
require follow-up questions. And unlike extraneous influences, where you can say, okay, we only want to inquire about whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations?
Right. So here's pretty interesting. So so the judge is saying, look, I couldn't ask them, like, were you set on, what are the votes on, do you agree on any charges, without getting into possibly opening the doors to some really not kosher questions that really get into how the deliberations are going and who feels what way and where the votes are. Which even the state said after the fact they couldn't even get into a conversation at all. They didn't want to open the door at all to being seen as getting into those. So I think this is a loser. Does this not sound like a loser argument? Am I the only one here who sees this as a loser argument? And even in, very defense-friendly Massachusetts, that you're not going to win with this argument here? I mean, maybe they'll surprise me. Maybe, you can always be surprised, but I don't see them getting anywhere.
Inevitably.
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. 1, did you take a vote on count 1? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that going to... The jury can change its mind, right?
Who's finding these arguments super persuasive? Because there are times when I'm watching these kind of hearings, and I know that I'm not on the defense side, but I will find the defense incredibly persuasive. I'll have to stop myself and say, hey, wait a second. The facts are this, that, and the other. Didn't this just happen? What about that? But in this case, I'm not finding Weisberg at all persuasive. I'm just going to go to hold on one second. I'm just going to go put up just a little poll for you guys. So I'm really curious how you're feeling. 'Cause I'm not finding this a good argument, a persuasive argument. Finding it legally incredibly unsupported. I mean, I don't know all the case law, but just from living life and okay, here I go. Just typing it in. Give me a minute. Actually, let me just put it back on as I'm typing this. Look for the poll. Because I'm curious how you guys are feeling with this.
But isn't that going to result in asking that type of question? When you say final, if you don't get your way on 2, is it final?
Was it ever reconsidered? My contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, I didn't agree.
They also don't write in saying we agree with the other 5 or anything to that effect. They're silent. as their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished, they weren't finalized, and you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser includeds. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafker's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, we allow a court to ask about mental processes. Was there communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source. Right, but when
it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not guilty?
So the question asked to juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2. We were not yet done.
And that would reflect two things.
The jury deliberations, right?
That would reflect that the voir dire by the judge.
Has anyone figured out this clock thing? What the heck is up with the clock? Sometimes it goes down to 1 minute. I'd love to know how this clock thing works.
Did not lead to a result of a final.
So it seems like we're at, 78% find her. Is that 80? And it went down to 78%, not persuasive. Let's see where we're at. Hold on, I'll give you a poll update. We're at 79% no, 12% yes. They find him persuasive. Karen Reed's defense team. Somewhat, 4% don't know at a staggering 6%. Okay. Yeah, I just don't find him persuasive. The phrase grasping at straws comes to mind. Desperado, why don't you come to your senses? I'm in such a good mood today, guys. Oh, getting Gascon out, that slimy little horrible creature of a DA in Los Angeles has really put me in a very good mood.
Unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Kearney, if conducted, that was my vote. It was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of...
Patricia, yeah, since you missed it, I'll be right back with this, but we just have to... Yeah, you missed it. You missed it. Are you getting that incredible 61.5% to Gascon's 38.5%? Nathan Hochman is ousted, won over Gascon, who is ousted. I mean, how sinister do you have to be to create a plan? So, to basically subvert, our justice system, be like, hey, a great way to win every time and do all the things we want to do for the defense and get all these criminals out is just to get rid of the prosecution altogether. Who would think of that plan? If a bunch of prosecutors got together and thought up a plan to get rid of, to be actual defense attorneys and work against their client's best interest. Hey, let's get people like Karen Reed convicted by just having her have a crap defense team. No one would be on board for that on this side. I mean, that's the difference.
Jurisprudence that says we presume that the jury follows the instructions.
Okay. And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The Capen case.
That's not this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
before you shift back to that, yeah. What's the best case? That's federal, because we're interpreting federal law here. What's the best closest case, and not an extraneous influence case, allowing this type of probing after, if we want to go back and read one case that's going to do what you want us to do, what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State, that the amici brief brought us to, where they read the newspaper.
It's a state court case, right?
Yes, it is.
Any federal cases, because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case that has the. You're asking us to direct Judge Kearney to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
Right. He's like, come up with one federal case. Because you're saying, I guess they're arguing your federal rights have been violated here. He's like, give me one federal case that supports your argument. Here's the answer. A lot of stuttering.
This court has a long history of applying federal constitution.
We don't have any cases except extraneous influence cases. I'm just looking, again, your chance. You do best case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Again, that's extraneous influence. That's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, you know, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and
so the jurors submitted affidavits?
The jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedents to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules of Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to...
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
Right. So he's saying, like, look, hey, hey, dude. Hey, Karen Reed's $5 million defense team. And now that's from Karen Reed's own mouth. And I would call her not a reliable witness. I mean, not a reliable narrator. Hey, you got to know where it's going. Once Tui Rodriguez is read, meaning every lawyer, even ones just out of law school, know that it's heading towards mistrial. You've got experienced trial lawyers here. They know where it's going. Can you show us anywhere where it was argued that they didn't have the opportunity to look at alternatives like, hey, are you in agreement on any of the charges? Can we just declare a mistrial on this charge and this charge and come up with a verdict on something? It's absurd. Heisenberg says, leaked text messages are just the beginning with Karen Reed and Turtleboy. Yeah, I'm really curious to see what Sean says in a half an hour on Masshole Troll Mafia. I saw people were already lining up an hour ago to watch Kate's show. I'll certainly be amongst them, and I'm really curious to hear what he has to say. Turtleboy's upset with M. William Phelps because they share the same manager. And he signed a contract saying that he wouldn't disparage the podcast. And he went on a whole what was it, 4 hours, 3 hours, 2 hours show disparaging M. William Phelps. He goes, nobody wants to hear the Karen Reed is guilty side of the argument. You got to come up with something fantastical, guys, to really bring in the big bucks. But I'm supposed to promote this. So I stand by my theory that M. William Phelps is just as grifty as the rest of them. He just wanted that's my opinion. He wanted the free Karen Reed side and he wanted the Karen Reed is guilty side. He wanted the whole audience. So how do you not alienate one side of the audience? You get Turtleboy to promote the podcast, so you get them listening, and then you say Karen Reed is guilty. Done. I mean, I just know that we can do so much better when it comes to true crime reporting. I mean, we've gone from Dominic Dunn. I was talking about him today. So powerful. His victims' families' voices are so often so powerful. And he brought a kind of flair, a little gossipy flair to his reporting, but a real righteousness, not self-righteousness, but righteousness to his reporting. Where is that? And a keen eye for detail. Where is that? Where is that now? All we have is just this pro-murderer, grifty, fantastical reporting. Facts kind of don't matter. Just tell a fantastical story. I mean, is this where we've gotten with our media? We just hear these fantastic stories every day, that the demand for them to be even more amazing and jaw-dropping is just getting greater every day. I mean, have you guys seen 3 Identical Strangers, that documentary? That story is unbelievable. You know, 3 twins separated at birth, part of a larger program to separate identical twins to see nature versus nurture, which one was right. I mean, essentially. Also, some of the financial elements, parent rearing, and they found each other after years of being separated. I mean, is the demand for just more amazing stories? So when you have true crime, why work within the confines of the actual evidence? Just go hog wild and invent a conspiracy theory. That's one element of it. That'll bring in the bucks. But the other element is really to push an ideology that our police officers, in this case, our police officers, are the real criminals out to frame innocent citizens, and that things that were just making the best of a difficult situation, like a nor'easter, like the solo cups, etc., or some kind of nefarious thing, or the reversed, or the mirrored, I'd call it mirrored video image, some kind of nefarious hiding something. They all have something to hide because no one likes Karen Read. Really? I mean, still have yet to have a free Karen Reader tell me how this happened from beginning to end. Tell me their version of it.
Let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
the judge said they're at an impasse, bring in the jury?
Bring in the jury, and you can actually hear a door open.
Okay,
so
and you have 30 seconds to object.
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the jury.
You can't say, Your Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in the note.
But they did know that the jury had reported to her that they were at an impasse.
They were at an impasse. Okay. Bring the jury in. Yes, that was possible. But to ask to go to the bench, but yes. This court...
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a...
This is a lot of the same stuff. Are you guys getting bored of this? I don't know. I'm going to let it go for five more minutes, but I get it. You got nothing. You got nothing. Called grasping at straws. I'll call this Karen Read's grasping at straws hearing. Let me know, but I'm kind of getting bored.
Second prosecution, the trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial, correct?
After a careful consideration of all alternatives and after giving the defense an opportunity.
Explain why, perhaps, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted the verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives Tui?
There's something I've never seen. Let me give you a hint on the judge's thinking. The judge didn't inquire on their thinking because it was the third note and everyone knew it was headed for mistrial, dude. And here's this guy back again with the case law. Hey, can you give me any case law? Can we just cut all this nonsense short and give me one case that you're basing this on? Heisenberg says, thanks, Heisenberg. It is only a matter of time before the public becomes. Hold on one second. I didn't bring my glasses. I'm getting so old. Disinterested. Okay, let me start from the beginning. Sorry, Heisenberg. It's only a matter of time before the public becomes disinterested in the story. With that said, the money gravy train ends for Turtleboy. Yeah, I mean, he already came off as awfully desperate with the 34 Fairview M. William Phelps podcast. Like, just download it. Everybody, tell your friends, download this thing. It's total crap, but just download it. I need the money. He came off as totally desperate. I mean, you know, I'm not sure his power will end. It seems like with this, though, I think he will attach himself. They're talking a lot about the Justin Root story, that side. And that's a story that's actually close to my family, where a schizophrenic young man was waving a fake gun around a parking lot and then led the police on a high-speed chase. Caused it, I mean, you know, and was ultimately shot. But, you know, his family, his grandparents were like my grandparents growing up. I mean, that's how close our families were. And my mom asked me to look into it a long time ago. And I read all the documents and I was like, that's what happens when you wave a fake gun around. You can't, there isn't, and you're waving it around and leading the cops on a high-speed chase. At that point, you're not only is the fake gun seen as a weapon, but your car literally becomes a weapon when you drive it like that recklessly and cause a chase. So that's where it's going. You know, if there's a better way that they have to deal with situations like that of unwell people in crisis, I'm open to hear it, but it's just a sad story all around. But when they point to it, when the Free Karen Reed points to that case as some kind of misconduct or corruption, I don't know what they're talking about. It's the Justin Root story. So his name was spelled Justonroot. If you guys want to look up the court documents.
The judge gives Tui.
Yep.
And then the jury comes back and says, we're deadlocked. As articulate as this jury was or not. And then the judge does something different other than just declare mistrial.
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I contest.
But here the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes. Right. And in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that provides proof as to what the process was on July 1.
In the statute, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule.
All right, I'm just going to move forward to when the state answers because I've kind of had. Okay, here we go. I just want to hear. Is this Brennan for the state? I just want to hear his answer a little bit, just a little bit of it.
Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start.
Wait, so this isn't Brennan? So they put a new prosecutor on this? I want to hear that again. Hold on. This is someone else?
Good morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura.
Did anyone hear his name? It's like Marble Mouth, Marble Mouth for the Marble Mouth for the state. I'm Mr. Fast Speed Talker for the state. How are we doing on time? All right. I don't want to miss Kate's show.
I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the...
So they keep referring to their brother? Is that a... I've never heard that before. Is that a Massachusetts thing? If anybody knows? Is that... Do they mean my... I assume they mean my fellow colleague. But I've never heard... Has anybody heard that before? Is that a Massachusetts thing? Or is that a Supreme Court argument thing? Or curious? I've never heard that before.
Jury that they're prepared to find a defendant not guilty on a charge. Effective defense counsel is not going to ask the judge to start probing or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think.
Right, so it's like saying Debbie Gibby and someone else. Oh, it's just Debbie Gibby says it's like saying counsel, like counts when they refer to each other as counsel. Counsel makes the argument, counsel, but I guess it's my brother. I've never heard. So curious, Debbie, do you know when it's a woman, do they say my sister? It's like, it's almost getting like 60s. My sister councilwoman, my sister counselor. Has anybody ever heard? Oh, who am I thinking of? Oh, I'll think of it in a second. Who talks like that? The black progressive guy. I think he was running for president at one point. Love listening to him talk. He's really, I think he taught at Harvard or Yale for a little bit. He's like, he always says that. My sister here, my brother here. What my brother, Barack Obama, my sister.
Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or an obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what...
OCT wins with Cornel West. That's who I was thinking of. Thank you. I couldn't think of his name. I could see his face in my head. Cornel West. Yeah, Cornel West. They're all sounding like Cornel West. My sister, but he always does it like really with a flair. My sister Michelle. He's talking about Michelle Obama or whatever. He ran for president. Thank you, OCD. That was gonna drive me crazy.
A judge or a jury may do. I know the defendant argues.
So it's not inherently coercive.
So
the judge has a discretion, it can't be coercive, correct?
Well, no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion, and that's what the judge did consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
So that's what my brother, Mr. Fast Talker here, is saying. He's like, that's what I think the jury meant when they said we can't reach agreement on any of the charges. I think they meant that they can't reach agreement on any of the charges. I think that's what they meant. Wasn't really opaque, that note. That note. Funny. Okay, just 2 more minutes. I think we get the gist.
Exactly, but indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits, now 4 or 5 days of deliberations. They've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment.
Yeah, why did he make that argument? That argument's almost like the defense argument. He's like, they just didn't want to deliberate anymore, and they wanted out of there. They'd seen hundreds of witnesses, or he leaves the room to make that argument by saying, look, they were arguing for so long behind closed doors. They'd seen so many witnesses. They just wanted it done with. I think you really have to make the point that they didn't agree on anything. I mean, I know that's where he was going, but you know, this defense will jump on anything. And I think this is where the judge is going here.
Process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Yeah, certainly, Your Honor, and I think, you know, in hindsight, seeing, you know, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step, perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude The jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor.
Really?
You find consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two notes. And what was the defendant's response to those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor?
Because they wanted Tui Rodriguez, which this guy is arguing basically for, he's arguing for doesn't it sound like he's arguing for the defense? He's like, maybe the judge should have asked more questions and really gotten into their deliberations. Maybe in hindsight, that would have been a good idea. What the heck? Dude. I mean, this is one of these times where you see someone doing what I think is not the best job, and you think you think maybe I could do better. Get me in there. Put me in, coach. Can you pitch it? Like Legally Blonde. Can I just have someone to supervise me to get in there and let me make the argument? Guys, let's cut the crap. We all know that they're trying to grasp at straws here. We all know that there was turtle riders on this. Let's get to brass tacks, down to brass tacks. This was ridiculous. This guy, dude, you're not helping. You're not helping.
After being informed that the jury's at an impasse, they could have brought the issue up again during the scheduling conference after the jury was excused to the jury room, and even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room, and at that point the judge did still consider counsel's arguments. And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
Yeah, can you give me your best argument? I don't think this is a good way to go about it. I don't know. But I'm not a lawyer. I don't know. Even the judges seem unpersuaded by this. Strangely, it seemed like the defense was making a better argument for the prosecution than the state, than the actual state's case is making, just by their sheer lack of support of anything that they were saying. And their what I saw is coming off as grifty and grasping at straws. This, really, strangely, this is the weirdest hearing. And we're running out of time. I'll look maybe one more minute and then I'm going to conclude, but I just want to hear a little bit more. Maybe we'll finish this up tomorrow, some of it, because this is crazy.
This case is closer to Pellegrin, Your Honor, and very different than Horrigan. Mm-hmm. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Oregon is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not...
How do you know the defendant is advocating for a mistrial as opposed to...
Oh, right. They're saying they're advocating for a mistrial because they're asking for Rodriguez Tui. Isn't that funny, those legal things? Like, we all know that Rodriguez Tui is probably going to result in a mistrial. We already had a judge saying, that when you ask for Rodriguez Tui to be read, that probably they're going to come back hopelessly blocked. You hope that they don't, but that's where it's leading. But here's the thing. I mean, when you tell your wife you're cheating on her, you're not really asking for a divorce. You know what I mean? Maybe that's not even a good example, but it just seems inevitable, right? I was surprised after I told my wife I was cheating on her that we got a divorce. I mean, it's even more, I think that could go in so many different directions, though, and so many women do stay with men who cheat on them. So I'm going to work on my metaphors. We can get back to this another day. Thanks so much for watching. Please hit the thumbs up. Let's see where we are on our poll before I go. Okay. Karen Reed, we're at 71%. No, they don't find it persuasive. 14% persuasive. 9% somewhat. And 6% don't know. That's where we're at with that. Please hit the thumbs up, subscribe to the channel, share this episode. Leave me a 5-star review on Apple Podcasts. And I'll be back tomorrow at 6 p.m. with another episode. Have a great night, everybody. Yay, Gascon is out of there.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system, my clown.